Today we're talking about firing employees legally. Most business owners think that at-will employment means they can fire anyone for any reason. And honestly, that makes sense. If you can hire freely, you should be able to fire freely, right? When you hear at will, that's exactly what it sounds like it should mean. But here's what you don't know. That belief isn't always right. Wrongful termination lawsuits cost businesses millions in settlements every year. I've defended hundreds of wrongful termination cases, and I've seen the exact same preventable mistakes destroy businesses over and over. But I've also discovered there's a proven 6-step legal framework that makes you way more protected from legal claims. In this video, I'm breaking down this exact framework. The traps that create lawsuits, the documentation system that wins in court, and the one firing method that even employment lawyers can't touch. Let's dive in. There are times when you can fire someone right away without any warnings, but you should only do it if you follow these exact steps that so many employers mess up. Serious bad behavior lets you skip all the normal steps and fire someone on the spot. This works for theft, violence, harassment, illegal drug use, or refusing to do their job, amongst plenty other things. But here's the part everyone misses. You still need to investigate and write everything down. Don't fire someone when you're angry. Take 24 to 48 hours to talk to witnesses, gather proof, and document everything. Put them on an administrative suspension pending investigation in the meanwhile if you need to. Even with serious bad behavior, you have to show you looked into it fairly and had good reason to believe the employee did something wrong. Jumping the gun can work, but can often cause problems on the back end. This protects you from the biggest lawsuit trap: firing someone when you're emotional or haven't done your homework. Quick firings without investigation become sticky lawsuits, because if you didn't get something right, your true motivations get called into question. And that's enough to have you dragged through a lawsuit even if you didn't do anything wrong. That immediate firing power, it's strong. But if you don't have the right paperwork system backing it up, you're still open to the most expensive type of employment lawsuit. Your memory of what you said out loud isn't as strong as what you have in writing. The real magic? It's in your written proof that shows your firing was for real business reasons, not discrimination or revenge. This is called your paper trail defense. Start a file for every employee from day one. Write down every performance problem, rule breaking, and correction talk with dates, witnesses, and specific details. Use step-by-step discipline. Verbal warning, make sure you write that down, a written warning, final written warning, and then firing. Every step has to state the problem, what needs to improve, and what happens next. This system upgrades you from vulnerable to almost untouchable. I've seen businesses with perfect paperwork win cases even when the employee had a good lawyer and sad, relatable circumstances. Without it, even good firings become $60,000 plus settlements. But even perfect paperwork won't save you if you fall into this next trap that catches even the most experienced managers off guard. The fastest way to lose a wrongful termination lawsuit is to treat similar employees differently, and most managers do this without even realizing it. Uneven rule enforcement creates what lawyers call differential treatment, when you punish employees differently for breaking similar rules. This makes any firing look unfair and possibly illegal, even when it's not. Make a rule book that shows exactly what happens when someone breaks each rule. If being late gets a verbal warning for one employee, it gets a verbal warning for everyone. If you skip the normal steps for serious bad behavior, write down exactly why this case needed immediate firing. Use that same firing checklist for every termination. Being consistent proves you're making business decisions, not personal or unfair ones. Being inconsistent is the number one thing employment lawyers look for because it's so much harder to defend in court and makes lawyers and juries wonder if you're being honest about the reason that they were fired. Being consistent protects you from discrimination claims, but there's one group of employees where normal rules don't apply, and firing them wrong triggers federal claims and investigations. Employees with immediate protected statuses, pregnancy, disability, FMLA leave, workers' comp claims, have special legal shields. Firing them can create presumptions of revenge, which some juries will take as you're guilty until proven innocent, even if that's not how it actually works. If you have to fire someone with immediate protected status, write down the business reason thoroughly before they ever ask for help or leave. Show budget cuts, restructuring, or performance problems that existed before their protected activity. Never mention their medical condition or leave as a reason, and make sure you have legal counsel review that before you proceed. The timing alone can be enough for federal investigations and claims to get through. I've seen $100,000 plus settlements just because the firing happened within 90 days of a leave request, even when it was completely unrelated, just because it looked really suspicious. Protected status employees are high risk, but the actual firing meeting is where most employers accidentally create the evidence that destroys their defense. How you handle the actual firing meeting can make or break your legal defense, and managers often say exactly the wrong things. Everything you say in a firing meeting can be used against you in court. Emotional language, apologies, or personal comments become evidence of discrimination or retaliation. Keep it short, factual, and professional. Have an HR witness present. State the documented business reason briefly. Don't argue or explain too much. Don't apologize or express regret. Take notes from the meeting about what was said and the employee's reaction. Stick to your script no matter what they say. This isn't your time to give a speech. A professional firing meeting supports your paperwork and shows you acted reasonably and legitimately. An emotional or poorly handled meeting gives lawyers ammunition to claim the real reason was a cover-up for discrimination or retaliation. Even a perfect firing meeting won't protect you if you make these post-firing mistakes that create new legal exposure. Post-firing actions can create new allegations of revenge, lies, or interference with future employment efforts. Don't badmouth the former employee to staff, customers, or potential employers. For reference checks, confirm only dates of employment and their job title. Don't get revenge against employees who supported the fired worker. Keep all the paperwork, never destroy files or emails. Handle unemployment claims professionally based on documented facts, not emotions. You never want to give an employee or their lawyer a reason to ask more questions. Mistakes after firing someone can raise questions about your true motivations for the termination. Professional responses protect you from additional claims, questions, and show you acted in good faith throughout the process. Getting dragged into a lawsuit, even one you win, can be just as bad for your business as losing one. The reality is, firing employees legally isn't about avoiding tough decisions, it's about making them the right way. Now here's what we covered. Use immediate firing power for serious bad behavior, but investigate first, even if you have to put someone on a brief suspension pending investigation. Build bulletproof paperwork from day one. Stay absolutely consistent and disciplined. Handle protected status employees with extra care. Run professional firing meetings. Avoid post-firing liability traps. The cost of getting this wrong is $60,000 plus in legal fees and settlements. It's way more than the time it takes to do it right. Most businesses that get sued aren't bad employers, they just didn't know that these rules existed. Take 30 minutes today to check your current firing procedures against this framework. Create the paperwork templates, train your managers, and build the systems that protect your business. Because when you need to make tough personnel decisions, you want to focus on what's best for your company, not whether you're about to get sued. If you want help putting these systems in your business, click the link below. Thanks for watching.